before we start. I hope your lordships have 3 bundles, all relatively small, 1 core, 1 supplemental and 1 authorities.
Yes.
I'm grateful. There are, I think, on your lordship's desk a small collection of papers from Mr. Cohen, just a few small pages, and an updated index to the authorities bundle. As I understand it, he asks that you would add those 3 items to the end of your authorities bundle. They are an extract from Arledge, Eady and Smith on contempt, a 2013 case from the High Court called Lee Jones, and an extract from the Criminal Legal Aid Financial Resources Regulations.
Right, let me just find them at home.
Provided electronically as well.
My lord, no, I will endeavour to ensure that they are in
And the Lord, since the longest of those, I think, is probably the extract from Arledge, it may help, as I understand it, the section that Mr. Cohen wishes to refer to is on the second page, what's now numbered page 436, and it's extract 15-142 at the bottom of that second page.
Right. Yes.
Lords, thank you. Unless there are any other matters I can assist with the papers, I'll turn directly to the issue in the appeal. So as your lordships are aware, this is my client's appeal against the decision of Sir Anthony Mann of the 8th of April 2025 and the order he made consequent on that, both of which you have in your core bundle and I'll invite your attention to shortly. And that was to impose a contribution order whereby my client was required to make a full contribution towards the cost that the legal aid agency had expended in his defence of the contempt application against him. This appeal is brought with the permission of my Lord Justice Zacaroli of the 17th of July, which, just for your lordship's reference, is page 83 of the core bundle. Lords, in terms of the underlying facts, I'm going to deal with those very briefly because, at least for my purposes, we say this is a point of principle of general application where the underlying facts really are not the pertinent issue before this court. As your lordships will have seen, Sir Anthony Mann's decision followed his earlier determination that my client was in contempt of court for his failure to comply with disclosure obligations imposed under a freezing order. You have the earlier judgments, should it assist you, in the supplemental bundle. The liability judgment, the finding of contempt, is at tab 1 with March 2024. The imposition of a sanction of 12 months imprisonment is at tab 2 the following day, March 2024. And there was an appeal to this court which succeeded by way of a reduction to the sanction only, and that is behind tab 3 and is dated the 22nd of May of 2024. But again, unless it would assist your lordships, I'm not inviting you to turn those up. Our point is, and this appeal turns on the question of the proper interpretation of Regulation 2 of the Criminal Legal Aid Recovery of Defence Costs Order Regulations 2013, or as we've referred to them, I think on both sides, the Recovery Regulations. And our position in relation to this appeal is that there is a single correct interpretation of that regulation. It is not an issue of discretion or judgment. And whoever is correct, whether it be my client or Mr. Cohen's client in relation to this, that decision is one which will be of universal application to all recipients of legal aid in contempt cases, other than contempt in the face of the court, where those proceedings are heard in the High Court, and indeed we would say, as we will come on to see, probably also the County Court and the Crown Court will be affected by this. And that will have implications whether the person who has been accused of that contempt is convicted, is found guilty of that contempt, or indeed acquitted. There is a single ground of appeal, which I hope your lordships have seen. It's page 13 of the core bundle, and it is short. Our position, summarised in that ground of appeal, is that the judge erred, as a matter of law, in his conclusion that the reference in Regulation 2 of the Recovery Regulations to criminal proceedings before any court other than the Magistrates' Court or the Crown Court included within that definition civil contempt proceedings in respect of which criminal legal aid had been provided, and therefore erred in his conclusion that the recovery regulations applied to these proceedings at all. And of course, if we are correct about that, then the judge did not have the power to make the RDCO that he made, and if we're wrong about that, he did, and there's no appeal against the decision he made on that basis. So, my lord, the judge's judgment, as I say, is at tab 6 of that bundle. Again, I'm sure your lordships will have read it carefully.
Yes.
In short, and without intending to do any disrespect to the quality of that judgment, the judge rejected my client's arguments that there was a sufficient basis to conclude that there was a contrary intention to the presumption imposed by Section 11 of the Interpretation Act, that the words criminal proceedings in the regulation had the same meaning as those words in Section 14 of the Legal Aid Sentencing and Punishment of Offenders Act, LASPO. And for reasons that we identified before the judge below, and which we essentially repeat on this appeal, we say that that decision was wrong. Lords, in terms of the approach to this appeal, I would intend, subject to any contrary direction from your lordships, to firstly just briefly look at some principles of interpretation as they would apply to this case. Then to give a brief overview of our argument as to why we say the decision is both wrong but also would render material injustice. Then to turn to the detail of the regulations and the arguments, and then finally just briefly to respond to some points that Mr. Cohen's made, and to pull the threads of our argument together.
Yes.
So, Lords, in terms of the points in relation to interpretation, this court, of course, will be very familiar with the correct approach to the question of interpretation of statutory provisions. The matters are set out in paragraph 27 of our skeleton argument, and I just intend to take your lordships to some short points in relation to them. And if I can start, if I may, in the authorities bundle, tab 14, page 314.
This is cattle.
Lord, no, so this is the, sorry, I have the wrong reference, that's not a great start with my first reference. It should have been to the Interpretation Act, which is tab 14, yes, tab 14, page 314. Sorry, what's the right reference? So this is the Interpretation Act, Lord.
Yes.
So just to identify this, because of course this was a provision that featured heavily in the judgment of the judge below, we don't dispute its application. But construction of subordinate legislation, so of course what we're dealing here with is the RDCO regulations, which are made under the auspices of LASPO. So we're dealing with the construction, the interpretation of subordinate legislation, and Section 11 of the Interpretation Act provides that where an act confers power to make subordinate legislation, expressions used in that legislation have, unless the contrary intention appears, the meaning which they bear in the Act. And of course it was the core of the judge's finding below that Section 14 of LASPO has a definition of criminal proceedings which includes within it proceedings where criminal legal aid is provided for contempt other than in the face of the court, and therefore that expression, criminal proceedings, in Regulation 2 must carry the same meaning. So what we say we are looking for, and what the judge, we say, failed to properly identify, is the existence of a contrary intention which means that that definition from section 14 does not apply. We say ultimately that that exercise is not going to be markedly dissimilar from the general exercise the court will carry out when seeking to interpret a statutory provision as identified in the authorities. And your lordship slightly preempted me, but if I can now take you just briefly to the Packard judgment, which is tab 11. Page 163 of your authorities bundle. So this is the judgment of the Supreme Court given by Lord Sales, with whom the other justices agreed, dealing with an issue to do with the correct interpretation of the term claims management services in the Compensation Act 2006. We don't need to concern ourselves with the fine details of that, but in terms of interpretation, of your lordships will be kind enough to come to page 177. We have an extract starting at paragraph 40, where the Supreme Court, Lord Sales, sets out the relevant interpretive principles. And I'm not going to read, it carries on for just over 3 pages. I'm not going to read all of that. I'm sure these principles are very familiar to this court in any event. But if I may, I will just highlight within it a few short points. If we can come to paragraph 42, so having identified above letter B, as we all know, that the court's task within the permissible bounds of interpretation is to give effect to Parliament's purpose, at 42, his lordship came to the question of extraneous material and started with explanatory notes. It's legitimate to refer to explanatory notes, and then following the semicolon 3 lines down, but external aids to interpretation such as these play a secondary role, as it is the words of the provision itself, read in the context of the section as a whole, and in the wider context of a group of sections of which it forms part, and of the statute as a whole, which are the primary means by which Parliament's meaning is to be ascertained. And then following the reference to the case, he continues, reference to explanatory notes may inform the assessment of the overall purpose of the legislation and may also provide assistance to resolve any specific ambiguity in the words used in a provision in that legislation. At paragraph 43, his lordship dealt with the question of absurd results. The court will not interpret a statute so as to produce an absurd result unless clearly constrained to do so by the words Parliament has used. And then at the bottom of that page, he cites Bennion to the effect that the courts give a wide meaning to absurdity in this context, using it to include virtually any result which is impossible, unworkable, impracticable, inconvenient, anomalous, illogical, futiless, pointless, artificial, or productive of a disproportionate counter mischief. At letter B, of course, on the next page, he makes the point that that principle should, the court should be careful not to use that principle to substitute their own view of reasonable policy. And of course, we don't dispute that proposition. Lord, at paragraph 44, his lordship dealt with the question of using subordinate legislation to interpret a statute. His lordship concludes in that paragraph that that is permissible where it was promulgated at a time roughly contemporaneous with the Act. Of course, here we're not using the subordinate legislation to interpret the statute, but we do say the principle that other legislative provisions introduced as part of a package at the same time are a permissible interpretive aid. And I don't think that proposition is disputed. And then over the page at 180, the last specific reference I invite your lordship's attention to, paragraph 46. His lordship identified that the explanatory memorandum to an order that their lordships have concluded was relevant, the explanatory memorandum to that order was also a permissible aid to the interpretation of the statute. And as your lordships, I'm sure, are aware, in this case, we say that the explanatory memorandum to the relevant regulations is a permissible aid to the correct interpretation of that secondary legislation. So, my lord, again, we rely on the entirety of the principles which are well established and well known, which Lord Sales has set out across the course of those little over 3 pages. We say that if that process, that general interpretive process, is followed through, and the court reached the conclusion that we say it should reach as to the correct meaning of Regulation 2 in its context and in light of its purpose, and avoiding any absurdity or illogicality, then the court will also reach the same position for the purposes of Section 11 of the Interpretation Act, that gives rise to an obvious contrary intention to the idea that the secondary legislation should be taken to adopt the meaning that's contained in the statute for essentially the same reasons, because it would result in the same illogicality and for the same reasons would be contrary to the purpose that has been identified. Well, can I then move on to a specific further point, which is the ability of the court to consider where, should it reach that conclusion, the words of the relevant legislative provision do not achieve what was intended, and how the court should approach that question. And that was dealt with by the House of Lords in the Inco case, but if I may, I'm going to refer to that case through a decision of this court, which is the Cader and Eshaw case, which you have at tab 6 of your bundle, page 55. So this is a decision of the Court of Appeal of this court from 2017. Lord Justice Briggs, as he then was, giving the leading judgment with which the remainder of the court agreed. It was to do with a question as to the proper construction of a provision of the civil procedure rules. And as we can see, just briefly from page 55 in the head note, the central question just below letter D concerned a particular rule, Rule 45.29b, and that contained a provision saying that the only costs to be allowed in relation to the matters it covered were fixed costs. And the conclusion of the Court of Appeal was that that did not give effect to the intention of the rule makers, and that it was open to the court to add words to that rule to achieve the intended effect. And those words were, and for so long as the claim is not allocated to the multi-track. So in the relevant cases, the fixed cost did apply, but the Court of Appeal essentially wrote in an exception to that in order to give effect to what it considered to be the identifiable purpose intended by the rules. And so, my lords, within
which paragraph would you like us to
my lords, if we can come to page 66. So this is the analysis starting halfway down the page of Lord Justice Briggs. And just to note that in coming to the conclusion that the court was able to carry out the exercise that it did, letter F, 35 subparagraph A, the first point that Lord Justice Briggs noted was that there was no ordinary process of construction or interpretation of the wording of the relevant rules that could achieve the result that the court considered was necessary. Letter B, sub B to that paragraph, it was not a case where there was an apparent conflict between differing provisions in the different parts of the rules, nor, subparagraph C, was it a case where the wording of the rule was irrational on its face or could not itself have been intended. However, despite all of that, which of course are normally very important rules of interpretation of legislation, at sub D at the bottom of 66, by virtue of a careful analysis of the historic origins of the scheme and the process of consultation, the court was able to reach the conclusion that it was not the intention of those legislating for this regime that it should ever apply to a case allocated to the multi-track. So in short, the conclusion was that despite the fact that obvious principles of construction led to a contrary effect, that there was no obvious conflict or irrationality, nevertheless, the court could reach the conclusion that this must have been a drafting error. And as we see then at the top of 67, in that situation, just below letter A, the court has the power to put right by way of interpretation, even if, as here, it requires the addition of words, rather than giving the words actually used a meaning different from their natural and ordinary meaning. And in terms of legal principle to support that, at page 71, Lord Justice Briggs cited the House of Lords decision in the Inco Europe case and Lord Nichols' dictum in that case. And I won't intend to read this out, but perhaps if your lordships would be kind enough just to read what's between letters C and G.
Say sorry, Mr. Malnew, which page?
Sorry, my lord. Page 71. And it's paragraph 52, and I was asking your lordships if you'd be kind enough just to read to yourselves the quotation from Lord Nichols' speech in the House. Lord, thank you. Your lordships will have noted towards the end of that there are three factors identified by the court which must be present if the court is in a position where ordinary rules of interpretation will not allow it to reach the conclusion that's being sought. And those are that the court must be sure of the intended purpose of the statute or provision, that by inadvertence the draftsman and Parliament have failed to give effect to that, and thirdly, the substance of the provision Parliament would have made, although not necessarily the precise words Parliament would have used. So, my lord, just pulling those principles of interpretation together before turning to the substance of this appeal, it's our position that we say the court can, using ordinary principles of interpretation, so before we get to the Inco approach, the court can divine here what the correct meaning of Regulation 2 is, applying conventional principles of interpretation. The court can adequately identify what the purpose of that regulation is and can give effect to that purpose. And as part of doing so, we say it can be identified that the contrary meaning that the legal agency presses on this court and that the judge below found will be shown to lead to irrationality and conflict within the regulatory regime. But if we are wrong about that, we also say that if the court cannot reach that conclusion by application simply of a an interpretation of the plain meaning of the regulation, the court can adopt here the INCO approach, because we say the purpose of the provision can be properly identified. If we are wrong, and that effect to that cannot be given by virtue of ordinary principles of interpretation, then it must follow that if that provision does not give effect to the identified purpose, that there has been, by inadvertence or otherwise, an error whereby the draftsman has failed to give effect to that purpose, and the court can be satisfied as to the substance of the provision that Parliament would have made had it noticed the error in the bill, even if it could not be satisfied as to the precise wording that Parliament would be used.
Error in the bill or error in the reg?
Sorry, in the regulations, my lord. The error in the
And
provision.
it's the minister rather than
Yes,
Parliament.
indeed. Sorry, your lordship is quite correct. The error that the legislative have made and the substance of what the provision would have said had that error been noticed. So, my lord, against that background, I'm going to turn in a moment directly to the regulations, but just before I do, if I may make some short points by way of overview as to our position. So the first point we make is that if the decision below and the position of the legal aid agency is correct, we say we are in a rather stark position in terms of the question of individuals who receive criminal legal aid in respect of contempt applications brought against them. If the legal aid agency is correct, the position that they advocate is a position which, as we understand it, has therefore been in place since the introduction of LASPO and the regulations in 2013. But until, as far as we are aware, and the legal aid agency hasn't said to the contrary, has never been exercised before this case. That is despite the fact that if the legal aid agency's interpretation is correct, the courts have an obligation, a statutory obligation imposed by the regulations to consider the imposition of a recovery of defence costs order at the conclusion of proceedings where legal aid has been provided on this basis, and so would have had a statutory obligation to do so in every such case since 2013. So it's not a matter that is merely responsive to an application, it is an obligation imposed on the court. Within that, of course, it would also mean, if correct, that on every occasion when there has been a conclusion of proceedings where an individual received criminal legal aid for the defence of contempt proceedings, the legal aid agency has been failing in its duty to seek to recover those costs from the individual at the conclusion of the proceedings. And it would also follow that practitioners, and indeed to the extent that they ought to have been aware of it, the recipients of that legal aid themselves, have been responding to those civil contempt proceedings brought against them on the basis of a misunderstanding as to their exposure to repaying to the legal aid agency the costs of those proceedings. A secondary point we make in relation to that, my lord, if I can just, if your lordship still have the authorities bundle open in front of you, is by reference to a decision of this court in a case called Haringey, London Borough Council and Brown. So that is page 74 of your authorities bundle, tab 7. And lords, this was a decision of this court in which it decided that the sort of legal aid that we are talking about, so criminal legal aid under LASPO, was available in the context of contempt proceedings, contempt not in the face of the court, brought in the county court. So that was the substance of this decision. But if I can just invite your lordship's attention to page 76 and the judgment of Lord Justice McComb. paragraph 3, he identifies that the judgment in Bunning's case, and I dare say your lordships are aware of it from the arguments, but the Bunning case was the case that confirmed that legal aid post 2013 for contempt proceedings in the High Court was criminal legal aid. So the judgment in Bunning's case now enables a suitably informed and legally qualified advisor, as opposed to a layperson equipped with the statute, regulations and judgment, to resolve the conundrum that arises in High Court contempt proceedings. That is not so, however, in county court proceedings. The question of the availability of legal aid in such proceedings needs to be clear to layman and lawyer alike. It is not. The legislation is disgracefully complex. For this reason, in my judgment, the tenant's entitlement to legal aid in this matter was never properly understood and determined by the legal aid authorities, and in consequence, the proceedings in the court below went wrong. So, in my submission, the importance that the Lord Justice McComb is highlighting there is the importance for people who are subject to matters as important as contempt proceedings, that the availability, and we would say the implications of the availability of legal aid, should be clear and obvious to those who are involved in them. And whilst with a degree of optimism, the Lord Justice McComb in that case indicated at the start of paragraph 3 that the position in the High Court had now been resolved, the conundrum in the High Court had been resolved. In fact, if the legal aid agency here is correct, that he was quite wrong about that, because everybody had been operating since 2013 on the assumption that yes, we now know legal aid is available, but until 2024, nobody had suggested that a consequence of that availability of legal aid was the exposure to the recoverability of the entirety of the costs provided to you by legal aid at the conclusion of those proceedings, and possibly even whether you were acquitted or not. And so the conundrum continued because...
But isn't that so in the Crown Court?
My Lord, no, it's not so in the Crown Court. With contempt other than in the face of the court, if there were contempt proceedings...
No, I just meant in standard. In a Crown Court trial, you're exposed to paying a great deal towards your legal aid.
Lord, you are, yes.
Although at the end of the case.
Well, no, my Lord, in a Crown Court trial, you're exposed to an income contribution as the proceedings go along if you are legally aided. So there are certain financial limits set depending on your income, whereby you may have to pay a contribution as the proceedings go along.
That's still right, that it's as you go along.
So it's both, my Lord. So there is an income contribution we have the regulations in the bundle and we may come to them. So there's an income contribution as the matters go along. And then at the end, if you are not acquitted, you are exposed to a capital contribution. If you are acquitted, then the income contribution is repaid to you unless the court determines otherwise. And of course, you're not then exposed to a capital contribution. But to come to my Lord Justice Bean's point, absolutely, the position with criminal trials in the Crown Court is that you are exposed to a contribution. But that has not, as far as we are aware, ever been understood until this case to be the position with contempt proceedings. And I say contempt proceedings, obviously contempt proceedings other than contempt in the face of the court.
Yeah.
And that is, on my case, insofar as we need to come to it, also the position in the Crown Court. So if you found yourself in what perhaps might be thought to be a slightly unusual position, but nevertheless a position which is open in principle, which is that you are subject to contempt proceedings in the Crown Court, the provisions on financial contributions and recovery of costs at the end by way of other contribution do not apply to you. So they only apply to essentially criminal trials and appeals to the Crown Court from the Magistrates Court.
That's right, you say, irrespective of the argument.
I say that's right, irrespective of the argument in this case.
I thought it was written somewhere, maybe in Mr. Cain's skeleton, I'm not sure. That, if you are a defendant in the Crown Court and you become respondent to breach proceedings, breach of a Crown Court order, of which there are many and various now. The Crown Courts don't just send people to prison, but they'll fine them for mandatory orders. If breach proceedings are taken against you, it is said you don't get legal aid at all unless you satisfy a means test.
My lord, now I think one of the difficulties with all of this, and to some extent I've been guilty of this because terms are bandied about such as civil contempt and criminal contempt.
Yeah.
The material distinction under the legal aid regime is between contempt in the face of court and other forms of contempt. Yes. And so that's the material distinction. And where we are in the position of other forms of contempt, that is Section 40H legal aid, that's the legal aid that is provided because it's required to be provided because a person is exposed to the risk of imprisonment, and that a failure to provide, at least in principle, legal aid would be seen to be a breach of their Article 6 rights. That's the argument that was dealt with under the McKay case before April 2013, and is the reason why such legal aid is provided, albeit that it's criminal legal aid. So legal aid for contempt not in the face of the court would be available in principle, but the recovery regulations, the Crown Court contribution regulations, I should say, because they're the contribution regulations, not recovery regulations. The Crown Court contribution regulations that apply to requiring you to make an income or capital contribution do not apply to proceedings in the Crown Court that would fall within Section 14H. And the reason for that, my lord, is because the contribution regulations specifically set out within them those forms of Crown Court proceedings to which they apply, and they are in short Crown Court trials and appeals from the Magistrates' Court. So it would be a set of proceedings that was outside the contribution regulations, but within Section 14H and the provision of legal aid.
So the person who is pursued for contempt for breach of a Crown Court order gets legal aid that is not means tested.
My lord, they are means tested. The Crown Court financial eligibility criteria apply, so they are means tested.
Right. But there's no obligation to make contribution.
No.
So how does that work?
What's the purpose of means testing in the first
place? Lord, I have to admit, that's an interesting question to which I've not got to the bottom of. The question that I considered was whether the contribution regulations apply, and on their face they don't. Quite how that interacts with financial eligibility, I have to admit, is something I've not got to the bottom of, and I may need to give a few moments thought to.
But on any view, the recovery regulations don't apply.
The recovery regulations don't apply. So in the Crown Court, the different regulations that you have are the criminal legal aid contribution orders regulations, which you have at tab 23 of your authorities bundle. I don't think we did below. I think the entirety of those was before the court. I don't think the entirety of them is, but if need be, we can identify the different parts, because in terms of those regulations, they're in two parts. Part 2 applies to Crown Court trials, part 3 applies to appeals to the Crown Court. There is nothing which would apply them to contempt proceedings before the Crown Court. So they don't apply. We're just checking more on the point about the financial eligibility. It was my understanding, but I'm just a little cautious to make sure that my understanding is correct, that the financial eligibility regulations apply. I'll check that. But responding to the Lord Justice Bean, the point I wanted to make was that, yes, in ordinary Crown Court trials, if I can use that expression, there are a set of regulations which impose income and capital contributions unless you're acquitted. But that doesn't apply to Section 14H contempt proceedings before the Crown Court. Well, I'll come back, if I may, on the point about the financial eligibility regulations, just to make sure that we have that point correct. Going back to where I was with the judgment in Haringey, the point I was seeking to make was that the idea that Bunning had in fact resolved the conundrum such that a suitably informed and legally qualified advisor was in a position to understand the implications of the application of legal aid in the High Court appears to have been an optimistic conclusion. If everybody since Bunning has been proceeding on the assumption that legal aid was available for those proceedings, bear in mind it's available without a merits test and without a financial eligibility test, but the point that everybody would appear to have been missing is that you are exposed to repaying the entirety of that, and the point I'm going to develop in just a moment, prima facie, if the legal aid agency's interpretation of these regulations is correct, there is no automatic provision that if you are acquitted, in inverted commas, of the allegation of contempt, that they won't apply and you won't have to make a contribution. And that again is stark because, again, and there's no dispute about this. For example, even in the Crown Court with Crown Court trials, the issue that Lord Justice Bean raised with me, there is express provision in the contribution regulations in the Crown Court that if you're acquitted, that you won't be subject to a contribution unless there are exceptional circumstances. You'll get everything back that you paid, and that you won't have to make any further contribution if you're acquitted. So in those proceedings, and indeed in higher proceedings, so for example appeals to this court or to the Supreme Court in criminal matters covered by the recovery regulations, there are express provisions providing that if you're acquitted, the starting position is you do not have to contribute. But that
Surely
would be
that's
absent.
less of a problem in contempt cases, because you may get an order for costs against the claimant who was seeking to have you committed.
Well, that's a possibility, and that is something that Mr. Cohen prays in aid. But of course, we would say is not an adequate answer to this. First, that it wouldn't explain why there would be the same presumption that applies in other proceedings would still apply to you. It would be perfectly possible, akin to the provisions in civil legal aid, to have a provision whereby you could seek to recover costs from your opponent, and to the extent that you'd received legal aid, you could then, out of those costs, you're required to account for those to the legal aid agency to recoup its outlay.
Yes.
That doesn't explain why you would start from a position whereby you were still exposed to paying the legal aid agency for the legal aid costs, whether or not you got a costs order from your opponent. So the court might not award you your costs from your opponent. It might only award you a percentage of those costs. Your opponent may, probably slightly unusually in the context of contempt, but it's not impossible, may be impecunious or go insolvent. Your opponent may
very
be difficult
unusual.
to enforce.
I mean, it's possible in theory, but
It's possible in theory. And the Lord, of course, what we're looking for is a construction of these regulations which doesn't just satisfy the desires in a particular case. So, for example, the legal aid agency may say in this case, well, why should Mr. Turk not pay something here? Yeah, he's been found guilty of contempt. But what we are looking for is a construction of these regulations that avoids absurdity and illogicality in their general application. And so, coming back to the point about adverse costs orders, my lord, it doesn't adequately explain why you would start from a position of it doesn't matter whether you get an adverse cost order or not. We're not going to say that if you get an adverse cost order, you account for that to the legal aid agency. We're going to start from a position that the court still should impose a costs order against a recovery order against you, requiring you, imposing a debt on you to repay the legal aid agency that money, regardless of whether you get a costs order against your opponent, regardless of whether that costs order is enforceable, regardless of whether it's a partial costs order, and regardless of whatever sum you might be awarded. There is an undoubted logicality, my lord, if I may be so bold, in your observation that recovery of costs in civil contempt proceedings might well lead to a recoupment by the legal aid agency of some of their outlays. That makes perfect sense. It's akin to the general civil position. But what it doesn't explain is why, if that was the intention, the regulations would operate in the way they do, which is not to refer to that, not to put that as the operative presumption, which might then result in an obligation to account, but instead just to leave a freestanding obligation on the court to impose an RDCO against the acquitted contemner. So, and of course, the context of all of this, we say, this touches on the point about adverse costs and opponents' costs. The existence of this obligation, if it is correct, that in civil contempt cases, the court must consider the imposition of an RDCO and indeed must, save exceptional circumstances, impose an RDCO, has the danger, along with the other aspects of contempt proceedings, of creating a real chilling effect for those alleged to have committed contempt in terms of their willingness and ability to oppose that application. If the legal aid agency is correct, then somebody accused of such contempt faces not merely the risk of an adverse finding and all of the personal financial consequences that might come with that, not merely the risk of an adverse costs order being made against them to pay the applicant's costs, with of course, in that position, no adverse cost protection, so they don't get legal aid adverse cost protection. That was made clear in the Curian case. So they have no obvious adverse cost protection, they're exposed to that risk. So they're exposed to all of those risks, and if the legal aid agency is correct, on top of that, they are then exposed to the risk of having, at the end of the case, to be told that they have to repay the legal aid agency its costs, subject to any limits on the capital contribution sum. And again, I make the point, and we'll come to the regulations in just a moment, that that's the starting point in these cases, even if acquitted, let alone if convicted. And it is not difficult to see that somebody who is subject to an application that they be committed for contempt, informed of the fact that it is not obvious even that if they're acquitted, they will avoid this obligation to make an RDCO or to pay an RDCO, that in that situation that could have a very chilling effect on their willingness to oppose those applications or to seek representation to do so before the court. And of course it's a powerful tool. That additional threat, that additional risk is a powerful tool in the armoury of opponents who may wish to bring such applications. And again, the point on acquittals, I've made the point already, but it is in stark contrast, for example, to the position in the Crown Court, where on an acquittal the court has no power, save in exceptional circumstances, to impose an order. If the legal aid agency is right about this, even on an acquittal in High Court contempt proceedings, the starting point is that the court will impose an order, save in exceptional circumstances. So a complete opposite starting point, which makes no sense.
Do you know whether defendants acquitted in the Crown Court have always been entitled to get their legal aid contributions reimbursed subject to contrary order? My impression, but only as a reader of newspapers rather than as a judge, was that it used not to be so, and there were many cases of people who were prosecuted, acquitted, but still bankrupted or nearly bankrupted because of the huge cost of the case. But maybe that was just because of special orders being made.
I don't know off the top of my head, Maud, and perhaps it might assist just briefly to turn up the relevant position. It should be page 389, I think, of your authorities bundle, which should be behind tab 23, since we are discussing the question of the Crown Court. So this is part of the Criminal Legal Aid Contribution Order regulation. So these are the regulations that apply. The term contribution order covers both income contribution orders during the lifetime of the case and capital contributions at the conclusion of the case, or additional contributions at the conclusion of the case. So section 25 deals with that assessment of representation on the conclusion of the proceedings. And so you can see there, it's letter B, where the trial judge considers there are exceptional reasons why an individual who is acquitted should be liable to make payments under a contribution order, ... the director must calculate the cost of representation. So where acquitted, you are only exposed, in the Crown Court, you're only exposed to such an order if there are exceptional reasons, exceptional circumstances, for want of a better word. And just to complete the loop in relation to the Crown Court, page 396 has regulation 37. And so this deals with the question of repayment in general. Sub 1, where an individual has made a payment under an income contribution order, so that's as the matter goes along, and proceedings are discontinued, or sub 2, the individual is acquitted of each offence with which they were charged, then under a contribution order, and the Court of Appeal has allowed an appeal, so they've paid something at the end of the Crown Court proceedings, but then the Court of Appeal overturns their conviction, then the Lord Chancellor must repay to the individual the amount of each payment made, together with compound interest. So the starting point in the Crown Court is acquittal. Anything you have paid is repaid to you, and the court cannot make an end case, if I can put it that way, an end of the case contribution order unless there are exceptional reasons, exceptional circumstances. As we say, our understanding is that in any event, these regulations would not apply to a section 14H contempt proceedings in the Crown Court, so there wouldn't be any contribution required in the first place. So we said those are very stark contrast to the position if the legal aid agency is correct as to what the position is here. And so perhaps the easiest way to look at what the position is here is to look at the regulations that we are considering, which are the very heart of this appeal. May I do that firstly by looking just briefly at the equivalent regulations which preceded these regulations, and then come shortly to look at these very regulations which are an issue.
Yes.
So in terms of the position prior to 2013, it is not in dispute. We know, there's no doubt, that legal aid for contempt proceedings, where the contempt was not in the face of the court, was civil legal aid. It was not criminal legal aid, and that's recorded in the case of Bunning, and that's not an issue. However, for criminal legal aid, where criminal legal aid was provided, there were regulations which dealt with the recovery of defence costs, so the recovery of the costs the legal aid agency had paid for your defence. Again, without wishing to overstate, to repeat the point too much, they didn't apply to the sort of contempt proceedings we're talking about now, but they are instructive because they are the structure that's then carried forward to the 2013 position when legal aid for civil contempt is included within the scope of criminal legal aid. And so, my lord, the 2001 regulations are at tab 17, starting on page 330. And so if we come within those to page 332, regulation 2, so funded defendants, the penultimate definition in regulation 2 was an individual who'd received representation in respect of criminal proceedings before any court funded by the Commission or the Lord Chancellor as part of the Criminal Defence Service. But then immediately, if we come over the page in terms of the ability to make recovery of defence costs orders, Regulation 3.1 excludes magistrates' courts from the scope of the regulations. Where an individual receives representation, ... the court before which the proceedings are heard, other than a magistrates' court, may make an order. If we come over the page, there are further exclusions, and this next regulation, Regulation 4, is quite important in terms of what comes next when we get to the 2013 regulations. So the judge hearing the case may make an RDCO against a funded defendant, except as provided in paragraph 2. Then paragraph 2, again, sub 1 excludes the magistrates' court, so where you appeared in the magistrates' court only. B excludes committals for sentence to the Crown Court, and C excludes appeals against sentence to the Crown Court. So all other proceedings, and in particular for our purposes, all of the proceedings in the Crown Court, including, for example, appeals against conviction or trials in the Crown Court, are within the scope in the previous legislation of an RDCO. And then there's a final exception, which is a sort of different category of exception. The first one's really you've been looking at the scope of making an RDCO, and then the last one deals with acquittal. And so the position for all courts covered by the ability to make RDCOs under these regulations for all courts is that in the event of acquittal, the court may not make the order except in exceptional circumstances. So that's not limited to appeals or anything of the kind. Anything that falls within the scope of the RDCO, if there is an acquittal, there is a reversal of the power, so it cannot be made save in exceptional circumstances. Now, when we then come to the 2013 regulations, which are tab 22, page 375, just before we come to the detail, the material difference in scope of the 2013 regulations is it excludes all Crown Court cases. So the 2001 regulations we just had in included Crown Court cases such as trials and appeals against conviction. The 2013 regulations exclude the Crown Court cases. And if we then come on within those, at the second page of these regulations, page 376, is the interpretation section, and the penultimate entry deals with the relevant proceedings. And this is the key definition, which is before the court. Relevant proceedings means criminal proceedings before any court other than the magistrates' court or the Crown Court. So again, that tells us that Crown Court proceedings are excluded, and the legal aid agency's position in relation to this is that that does what it says on the tin, and therefore any other criminal proceedings in respect of which legal aid is provided are within the compass of these regulations. And we say that cannot be correct because it would lead to illogicality and absurdity, and is contrary to what we can divine was the intention of these regulations. And so, if I may take your lordships on to page 378, at Regulation 5, we have recovery of defence costs orders. And so this provides, sub 1, that subject to the following regulations, 7 to 11, at the conclusion of any relevant proceedings involving a represented individual, the court must make a determination that they are required to pay the cost of that representation or such proportion of the cost as the relevant court considers reasonable. And we can see at sub 2 that the maximum cost is the full cost of the representation. So it's a mandatory obligation. It goes back to the point I made at the start, that this isn't something that, if it was always a requirement, has only been something that the court should be considering on an application. It is a statutory requirement at the end of any proceedings that the court must make a determination. something that in these types of proceedings, as we understand it, has not in fact happened since 2013 until the time of this case. Page 379 over the page, we then come to exceptions. One of the exceptions we can pass over children and other exceptions, children and benefits. So this is the nearest analogue to Regulation 4 that we saw in the 2001 regulations, which is the exceptions for acquittals. And your lordships will recall that Regulation 4 under the 2001 regulations simply provided, in effect, to paraphrase, that if you are acquitted, without any limitation, if you're acquitted, the starting point is no RDCO unless there are exceptional reasons. The heading of this it refers again, exceptions acquitted individuals, but if we look at 8.1, we can see that in fact what comes within an acquitted individual under this regulation is substantially more narrow. The relevant court must not make a determination in relation to a represented individual where the individual was before the relevant court to appeal against one or more convictions, and in respect of every conviction the relevant court allowed the appeal. So in fact, although it's headed exceptions acquitted individuals, this exception only applies to successful appellants against conviction. There is no exception which would reverse the starting point of the obligation to impose an RDCO for any other individual who is said to be subject to these regulations where they achieve what would amount to an acquittal. Now, the legal aid agency's position is that these regulations do apply to essentially first instance proceedings, and for the purposes of this, first instance proceedings as they could be deemed for contempt. And so we end up then with a material shift of position. A set of regulations where we are said it is the purpose and intent to expand the scope of these to include first instance proceedings for contempt, whilst at the same time a restriction of the exception for acquitted individuals so that it goes from a definition that would have covered anybody acquitted at first instance to one which only applies to those acquitted on an appeal against conviction. And that, we say, if correct, must reflect some change of policy. If it is intended that there are people within the compass of this who may be subject to these regulations but may be acquitted, but it is intended that if that is so, the exception under Regulation 8 will not apply to them, that must be a change of policy. Because otherwise, the very simple thing to do would essentially have been to port forward the wording that was in the original Regulation 4, which would have covered an individual such as Mr. Turk. So there is a deliberate policy, if the legal aid agency are correct, to restrict the scope so that only some of those who are acquitted will benefit from a reversal of the burden in relation to an RDCO.
Proposals brought forward when?
Sorry, Lord.
Proposals to change, you said, have been brought forward, or?
My Lord, no, sorry, my Lord, I think I may have misunderstood. My point in relation to this is that if the legal aid agency is correct, this must reflect a change of policy rather than simply bringing forward the broad exception.
In 2013?
Under the 2001 regulations. So when the change happened in 2013, if it's right that the intention was to bring in others who might be exposed to first instance proceedings which were within the scope of these regulations, but take away the exception that would have meant that if they were acquitted, they would not be exposed to an RDCO unless there were exceptional reasons. That must reflect some change of policy. Because otherwise, as I say, the simplest thing would have been to carry forward an equivalent provision to the 2001 regulations.
So far there's two major changes, aren't there? First is that prior in the 2001 regulations, RDCOs were available to proceedings in the Crown Court.
Lord, yes,
And that's removed by this.
correct.
And the second major change is that prior to these regulations, the legal aid that was available for breach of a court order in the High Court was civil legal aid, and that's now criminal legal aid.
Lord, that's also correct, yes. And just to complete the first point, the position in relation to, as we've seen already, Lord, I'm sure you're aware of, but as we've seen, the position in relation to contributions in the Crown Court was taken out and was put in the separate regulations that we've already looked at, which are the contribution regulations, which change the basis for Crown Court trials and appeals so that you can be required to make an advance contribution as well as an end stage contribution. So it's not that the obligation to contribute in the Crown Court went, it's just it was put into a separate set of regulations in a different form. And I'm sure your Lord, apologies for sort of seeking to hammer the point home, but your Lordship will have my point, which is that under those Crown Court regulations, the same position applies. If you're acquitted, that there is this switch whereby you can only be subject to an RDCO in exceptional reasons is the term used, exceptional circumstances. Just as used to be the general position under the 2001 regulations, just as we would expect to see being the general position under the 2013 regulations, no obvious reason why that wouldn't be the position under the 2013 regulations if those 2013 regulations were intended to do other than deal with what was left once you'd taken the Crown Court out of these regulations. And we say that that really is what is going on here. The reason paragraph 8 of the regulations, regulation 8, is limiting itself to references to appeals against convictions.
And page.
Sorry, Lord, page 379.
Yeah.
The reason it's limiting itself to appeals against convictions is because the other fundamental purpose of the recovery regulations, which was to deal with recoveries in Crown Court trials and Crown Court appeals, has been taken out and put elsewhere. So the general understanding was that these regulations apply to Crown Court proceedings and to appeals from those proceedings to the higher courts. In 2013, the Crown Court proceedings are taken out, put in different regulations, and what you're left with is the appeals to the higher courts. And if that's correct, Regulation 8 makes perfect sense. Makes perfect sense. If that's not correct, there is no obvious explanation why you would not have an equivalent provision to the previous Regulation 4, giving a general, for want of a better term, amnesty to those acquitted in relation to any proceedings that were covered by the RDCO regulations. Lord, can I just then invite your attention over the page to page 380? Because I don't want to preempt everything Mr. Cohen will say, no doubt because he will say it much more effectively and eloquently than I could. But if I can try and at least spike one of his guns, if I may, page 380, this is other exceptions. And so a material part of Mr. Cohen's case is to say, well, you're wrong about that because there's another exception, which means that the court can decide not to impose an RDCO on somebody who's been acquitted. And so his argument would flow. The starting point is that the definition in section 14 applies, so people who receive section 14H legal aid are within scope of these regulations, and the absence of an obvious exception where they're acquitted doesn't matter because of regulation 11, is broadly, I think, his argument. But the problem with that is if we look at regulation 11, it is plainly a wholly inadequate substitute and is directed to a different purpose. I'll deal with those in reverse order. In terms of being directed to a different purpose, if we look at the structure of these regulations, starting from Regulation 9 on the previous page, after the exceptions, what follows is dealing then Regulation 10, assets and income, and then we have Regulation 11, other exceptions, and then assessment of financial resources. And what follows from Regulation 12 onwards are the matters relating to assessment of financial resources, and in particular, the obligations of individuals. We see this at Regulation 16, page 383, to provide information and indeed evidence to allow the assessment of what they should contribute by way of RDCO. And that is, we say, the context of Regulation 11, page 380, which provides that subject to Regulation 17, and Regulation 17, just in passing, deals with when people fail to provide information. So you can't, if you're otherwise exposed to an RDCO, you can't escape just by closing the book and not providing details of your finances. That's Regulation 17. So subject to Regulation 17, the relevant court must not make a determination if it is satisfied it wouldn't be reasonable on the basis of the information and evidence available, or such a payment would result in undue financial hardship owing to exceptional circumstances. Now, those points we say are properly directed to a consideration of whether, on the basis of the information the individual is required to provide as to their assets, the court concludes that it would not be reasonable to make a determination. It's not directed to the question of acquitted individuals. Why would it be when you've got a separate regulation expressly headed acquitted individuals? So we say firstly that regulation is not directed to the situation we are considering, but the second point is, even if it were, it's not an adequate substitute, because what would be the policy-based justification for saying that for some individuals who are acquitted, in inverted commas, there is a clear switch whereby they cannot then be subject to an RDCO, save in exceptional circumstances, yet for other individuals who are acquitted, they are just left to a broad discretion of the court to decide what's reasonable in all the circumstances. What would be the policy-based reason for a distinction between those two? There is no obvious policy-based distinction. And the risk, of course, of a different starting point, it is fundamentally different before a court to be subject to an application where the court is told in relation to that application for one individual, it cannot do something, save in exceptional circumstances, and in another situation, the court to be told it has the discretion to make whatever order it considers reasonable in all the circumstances. They are manifestly different, and in particular, if there was a reason for a difference, what's the policy reason for that difference in the context of individuals who've been accused of contempt but found not to be guilty of that contempt? Why would those particular individuals, which are the other main category of individuals that the legal aid agency says are subject to these regulations, why would those individuals be picked out for a different test to apply to them? Now again, Maloney Friend's answer to that in part is to say, oh well, those individuals might be able to get some costs from the defence, which would mitigate their liability. But that's not a reason. Costs from the applicant, my lord, I apologise. Thank you, yes. They might be able to get some costs from the applicant, which would mitigate that liability. But that's not a justification for a different legal test to apply as to whether you impose an order in the first place. It would be a reason whereby, as indicated before, if such recovery is made, you are required to account to it, but it would not be a reason to leave an acquitted alleged contender hanging out there in the hope that they may be able to get some cost recovery, but in circumstances where the court is subject to a mandatory obligation to impose an order for recovery of costs, subject only to some broad discretion. So the final point we make in relation to that, Lord, is if that was right, though, again, third string of the argument, it's not what it's intended for. It wouldn't be a good answer in any event, but third string of the argument, if that is right, then it can only be that Section 11 is a reflection, we don't say it is, but this would be the consequence of the legal aid's argument, is a reflection of a deliberate decision to introduce a different policy for some categories of individuals subject to RDCOs to other categories of individuals. Because it would have to be an intentional decision to put those people in Regulation 11 and not in Regulation 8. Lord, may I then come to some external aids to the interpretation of this regulation? And the first is tab 25, which I'll pass over briefly. So that's page 403. So there is an explanatory note and an explanatory memorandum accompanying these regulations. The explanatory note is at 403, and in my submission doesn't take matters very much further, but I simply identify it for your Lordship's record. It repeats in the third line the term that's used in section 2, in regulation 2, which we've looked at.
Sorry, which page are we on?
Sorry, my lord, it's page 403. It doesn't, in fact, mention Regulation 8 at all in detail. It simply says in the penultimate paragraph, Regulations 7 to 11 set out the circumstances in which a court may not make such a determination. Of more interest, we say, is the next document, the next page, page 404, which is the explanatory memorandum, which, just for the avoidance of doubt, so as it says, this explanatory memorandum was prepared by the MOJ, it was laid before Parliament, it was contemporaneous to the statutory approval of the regulations, and is, we say, and I don't think this is disputed, an admissible document to the interpretation of the regulations.
Yes.
So if we look at paragraph 2, that expressly tells us what the purpose of the instrument is, and I rely on the last two sentences. Their general effect is to replicate in the new context created by LASPO the effect of the 2001 regulations. And importantly, there is no change in the underlying policy. So if we know the effect of the 2001 regulations, which is that anybody who was within their compass, if they were acquitted, there would be no scope for an RDCO save in exceptional circumstances. On the LAA's interpretation, under the 2013 regulations, new individuals are brought into their scope, but there is a change of policy in that those new individuals brought in will not benefit from that exception, but will instead be subject to a general test of whether it's reasonable in all the circumstances for them to be subject to an RDCO. That is a change of policy, if that's correct, but is contrary to what is said in this memorandum. If we pick it up under policy background at the bottom, paragraph 7, the very last two words on that page going on to the next page, these regulations substantially replicate the effect of the secondary legislation made under the Access to Justice Act 1999, so that's the 2001 regulations. And then the last part for my purposes, last two parts, at the bottom of the page going on to the next page, 8.3 records that there was no consultation on these regulations. I'll come back to that in a moment. And then over the page, 9.1, it essentially relies on the existing guidance for the courts and the judiciary on how to make an RDCO. So 2 points in relation to that. The first is we say it is remarkable if the intention was to bring those who are subject to contempt of court applications within the scope of these regulations and to make them subject to a provision whereby they are potentially exposed to an RDCO, even if acquitted, subject only to a broad discretion of the court, that there was no consultation on such a provision. The reason there's no consultation is because it would appear those making these rules did not intend or appreciate that that was the effect of what they were said to be doing. The second point over the page, by reference to paragraph 9.1, is that insofar as guidance already existed, again, if what is happening is here there is a material change, so original guidance, if people are acquitted, no RDCO save exceptional circumstances. New guidance, if people are acquitted, you have to look at what category of individual they are and the nature of the proceedings they faced, and then the power or discretion that you have to exercise in those circumstances is materially different than we would have expected in my submission to see additional guidance, but the only additional guidance that's going to be given is in relation to the determining of financial resources. So we say that all strongly speaks against any suggestion that there was any change of policy or any intention to bring a new category of people within the scope of the 2013 regulations.
What's the guidance specifically being referred to there that already exists?
My Lord, I don't know the answer to that. I don't think it's in the bundle. I'm not sure anybody has looked it up. We have some guidance as to RDCOs in the criminal proceedings, but we don't have the pre-2013 guidance.
I mean, you rather made the assumption that that guidance said, if acquitted, there will be no RDCO, but we don't know it says that.
No, my Lord, but I make that, I hope it's not an irrational assumption, bearing in mind the terms of Regulation 4 of the 2001 regulations, because they have no limit. Regulation 4 of the 2001 regulations just deals with acquitted individuals as a mass and doesn't then limit itself to those on appeal. It is covering all acquitted individuals. So I hope it's not an irrational assumption that either the guidance that would have existed would have simply directed the courts to the regulation and applied it, or if it gave any guidance, it would have been that acquitted individuals must not be subject to an RDCO save in exceptional circumstances, or, sorry, for exceptional reasons, to be precise. There's no reason, of course, there would be no basis for that guidance to have referred to either to the specific category of individuals who have been acquitted of contempt, because they would not have been within the scope of the 2001 regulations, everybody agrees on that, or to have identified a category of individuals who, it was said, were not automatically exempted from RDCOs subject to exceptional reasons, but instead were subject to some sort of general discretionary position.
But isn't it right that before Mr. Justice Blake's decision in King's Lynn and Bunning, that it wasn't clear that alleged contemnors get any legal aid from anywhere?
My Lord, we would say there was indeed that lack of clarity. I think Mr. Cohn would put it a little differently. He would put it that Bunning was simply confirming what he would say everybody should have known from the legislation. But certainly we would say that Bunning was the case that made clear it was necessary in order to make it clear that legal aid was available for, in inverted commas, civil contempt, and that legal aid was through the criminal legal aid regime, which of course was a change from the pre-2013 position. So one of the problems with all of this, we saw the words of Lord Justice McComb earlier. This legislation is not a happy, this legislation generally is not a happy set of legislation. It has taken, if we're right, a number of High Court and Court of Appeal cases to identify its precise ambit. There are still uncertainties. So, for example, Lady Justice Sharp in the NFU and Tiernan case raised the question of whether it is correct that there's no financial eligibility criterion applied to legal aid, but left that unresolved because it wasn't the issue before her. And we find ourselves here in 2026 dealing for the first time with what we are told is an obligation that was introduced in 2013 for the courts to make these sorts of orders in all these sorts of cases. This isn't happy legislation, and that goes to our point, of course, which is that the starting point for all of this is that individuals should not be required to make contributions at all for their legal aid, save where there is express provision providing for them to do so. And that provision, we say, should be clear. If a party is going to be held liable for what's essentially a significant financial liability, the provision providing that really should be quite clear and unambiguous. And this is not. This is plainly not. Where we say all of that takes us, Lords, is that the one cogent interpretation is that, however, whatever else we might think, is that these regulations do not apply on a cogent and coherent and logical basis to individuals who receive legal aid for contempt by virtue of section 14H of LASPO. How we've ended up in the position of this unfortunate set of regulations is a little unclear, but the most obvious explanation to us is the one that we advanced to the judge below and advanced again, which is that it is actually relatively easy to see what appears to be going on here, which is that the 2013 regulations take the Crown Court proceedings out of what was in the scope of the 2001 regulations. And therefore, if we're correct that matters such as these contempt proceedings aren't included, it's easy to see how the drafter of the legislation then gets to the point of saying, well, for the exception under Regulation 8 for acquitted individuals, now that we've taken the Crown Court out, that only applies to what was the other matter under the 2001 regulations, which essentially was appeals. And that would make cogent sense. But our fundamental position is whether that reasoning, trying to sort of second guess what was going on in the mind of the drafter, is correct or not. There is not a logical basis on which the provisions of Regulation 8 can be explained if it is correct that these regulations apply to those who receive legal aid or civil contempt. Lord, there is...
So you've been focusing on the injustice to accused of contempt and acquitted, to use that as shorthand. Your case must be then that no recovery of defence costs order can be made against a contemnor in any circumstance.
That is correct, Lord, yes.
Including when he's convicted.
Yes.
The taxpayer has paid for this element of civil proceedings. It's just too bad.
Lord, that is, I'm not sure I would adopt the expression, it's just too bad, but that is in essence the effect, yes. And I don't shy away from that. That is, it is perfectly logical, if I can put it that way, to see a policy by the government to say those who have received legal aid for defending civil contempt proceedings, if they are found guilty of contempt, should be required to contribute to or pay for that representation. That's an obvious policy that's open to Parliament, and it's easy to see the reason for it. If that were to be the case, though, we say that that is a policy that you would expect to see enacted in a transparent fashion with all the relevant and appropriate safeguards to that. And that's what we don't have. So I don't rail against the idea, Lord, that it's not difficult to see whether it's the man on the street or the legislative drafter saying Mr. Turk has been found liable for contempt. It's just that he should make a contribution. I don't rail against that. What I do say is that's not what this legislation does, and it is not what this legislation achieves. So, sorry, Lord.
I think one of the points you made just now and earlier was that if this legislation is to require an RDCO in these circumstances, it should be done clearly, and you say it's not. But it might be said that the simpler reading of the legislation is indeed that which the LLA contends for, because if you just look at the definition, and carry that definition through, it provides the answer they want. It's you that's got the hard work to do, isn't it, in saying that's not the way you should read that.
It is, I fully accept that, my lord, which is why I've not railed against, for example, the point about the Interpretation Act and that prima facie the definition from Section 14H is Section 14 of LASPO is adopted into these regulations unless a contrary intention appears. But we do say, for the reasons that I've been seeking to give and a few further short reasons I'll come to in a moment, that contrary intention does appear from the fact that if they are correct, the consequences of it are illogical. It leads to a situation where the sort of safeguards, the sort of protections one would expect to see are simply not present. It leads to a situation where there is an unjust difference of test between two categories of people with no explanation for it. It leads to something which could only amount to a change of policy in circumstances where the person responsible for the drafting of the regulations says in terms there is no change of policy. It leads to a change in principle from the approach under the 2001 regulations in circumstances where the person drafting the regulations says these are intended merely to essentially carry forward the provisions from 2001. And so if my learned friend was correct, or is correct, then what he seeks to achieve, or what he says has been achieved by this legislation, we say doesn't hold up once you look at the detail of how this legislation would work if he is correct. And that leads, we say, to the inevitable conclusion that yes, if you take a simple approach to this, and you just adopt, as my learned friend says you should do, the definition from Section 14, you carry that across, you can make this work. Yes, it renders potential injustice to some of the individuals in this. Yes, it applies a different test with no obvious reason to do so, but you can do all that. You can just pretend all that essentially isn't there and just carry on and do it. Yes, you absolutely, you can do that. But we say that would lead to the sort of illogicality which makes it plain that something has gone wrong here.
There's no power, is there, for the judge actually determining the contempt application and then sanction if he's found liability, to say, and you will pay or repay X pounds.
So the starting point in relation to that is Section 23 of LASPO, which is in the bundle. We can turn it up if necessary, but essentially provides that you can only be required to make a contribution to the legal aid that you've received by virtue of express regulation. And so there's no general discretion on the court to say we think it's just that you be required to make a contribution to the legal aid agency. And I come back to the point I made to my lord before, I addressed in front of your lordship before, yes. Which is I am not seeking to say here that there is no policy which could lead to a coherent set of regulations being introduced to require convicted contemners to make such contributions. We just say this isn't it. And in the presence of Section 23, if this isn't it, then there is nothing. And as your lordships will be aware, there is at the moment the Law Commission is conducting a review of the question of contempt, and in particular the difficulties of this boundary between civil and criminal contempt, and as I understand it is looking at matters such as the question of whether people should be required to contribute and how that should be achieved, whether it should be done at all, if so, whether it should be done by akin to the Crown Court way, whereby you sort of pay as you go along subject to an accounting at the end, or whether it should be done by capital contributions at the end, what the position is in terms of acquittals, whether in that situation everything should be refunded, quite how that should work. That's all matters, thankfully, for those far cleverer than me in the Law Commission. But that is being looked at the moment. What conclusions they will come to, we do not know. But it's no part of my case to say that if the Law Commission concluded that there should be a coherent set of regulations that said that an individual in the position of Mr. Turk should be required to make a contribution, that would be illogical or irrational. It's just not what these regulations, looked at in their context, do. So, Lord, I've dealt with the point about the reference to Regulation 11 and why that doesn't save the legal aid agency. There are a number of additional points that I just wanted to refer to relatively shortly, which are addressed in our skeleton argument.
Yes.
I'll just lay my hands
You
on
want
it.
to refer us to any particular passage in your skeleton argument?
Lord, yes. So if I can pick it up at paragraph 73. So we describe in our submissions there Regulation 8 as being something, this is the point about the exceptions for acquitted individuals, as being something of an anomaly. I would go, I hope I've made clear in my submissions, it's not just an anomaly, it's a fundamental problem with the approach of the legal aid agency. At paragraph 75, we pick up on some further points in relation to how these regulations interlink. And one concern that we raise, again, we can develop it by reference to the regulations if it assists, is that on their face, if the regulations are interpreted as the legal aid agency says that they should be, you can end up in a position whereby even a success on an appeal, so somebody who is committed for contempt, the High Court concludes that they, is subject to an application for contempt, the High Court concludes that they're guilty of that contempt, but they then successfully appeal those. In short, and I do rely on what's set out at paragraph 75, but in short, what is being said there is because each set of representation is dealt with under a separate representation order, if you take the regulations on their face, the High Court judge must determine the RDCO in virtue of the position in front of him, and a later successful appeal would not, at least on the face of these regulations, appear automatically to revoke or in any way undo that RDCO. And that is in contrast, for example, we saw it when we looked at the position with Crown Court trials under the contribution regulations, where your lordships may recall, the exceptions expressly included a position where a higher court overturns the conviction below in the Crown Court. There's no equivalent of that kind in these regulations, which would save a first instance contemner, that's the unusual introduction into these matters, from their liability for the first instance proceedings as a result of an appeal. And that's in part because the representation is under separate orders, but of course it's also because the exception in Regulation 8 under the regulations only applies to appeals, it doesn't apply to first instance proceedings. So that's why we say paragraph 76, if the LAA's interpretation of these regulations is correct, a defendant subject to an appeal, I think that should be an appeal from the High Court, remains vulnerable to an RDCO in respect of the first instance proceedings. That is, we say, just another example of the sort of lack of coherence and clarity of these regulations, which we would not expect to see if these regulations are to be taken to have intended to include first instance contempt proceedings within their scope. At paragraph 77 onwards, we have set out some additional points in relation to the contrast between the legal aid schemes. We've made the point at paragraph 78 that legal aid for contempt is said to be available on the basis that there are no financial requirements. In other words, there's no financial eligibility test. And as I've mentioned already, that has been queried by Lady Justice Sharp in the Tiernan case, not an issue that we need the court to resolve. In case it assists, over the page we have details of the relevant provisions of criminal legal aid in terms of criminal defendants being exposed to income contribution orders That's been largely covered in exchanges between the bar and the bench, but if it assists, it sets out at paragraph 83 onwards the relevant criteria in relation to those contribution regulations. One point to note is that in that situation, there are upper limits on the amounts that a defendant can be required to contribute by way of an income contribution order. There are no such limits in relation to the proceedings before us or the RDCO regulations. If I can come on to paragraph 94, an additional point that we make is that it would be perfectly easy if the legal aid agency wanted these regulations to have the effect that they say they have. It would have been perfectly easy for these regulations to have spelt out in terms what they applied to, and indeed to have addressed the points that we've made, etc., about Regulation 8. There would be no difficulty at all in these regulations doing that. We've given in that paragraph an example of a different regulation in the criminal legal aid remuneration regulations, which gives express reference to section 14H proceedings. So that could easily have been done here. For the avoidance of doubt, I don't say not doing so means they can't apply to those proceedings. We say they don't apply for all the reasons we've given. But the point we make is it's apparent on the face of the regulations that the drafter was aware of the ability, obviously, to make express reference to matters such as section 14H, where they considered that section 14H was expressly to be introduced into the scope of the regulations, and we don't have that here, and that contrast is notable. It's notable not only in its own right, but it's notable because of the contrast between that and where we get to when you try and then see what the effect is if section 14H cases are shoehorned into these regulations. A further point we make in relation to this is that it is easy to see in many ways a reason why, if there were to be a policy which led to the introduction of RDCOs in relation to proceedings of this kind, it is easy to see why that policy might favour contemners or alleged contemners rather than, as these regulations appear to do, if they apply, rather than disadvantage them. In other words, if you've got two pots of people, those who are subject to criminal appeals, who've always been subject to RDCOs, and then you add in alleged contemners, it's easy to see why the policy might favour the latter over the former. And that's because, of course, it could be said an RDCO serves an additional purpose, which is to make parties who have a choice in criminal proceedings think very carefully about that choice. And of course, appellants, who are plainly within the scope of the 2013 regulations, it is in the nature of an appeal that they are choosing to appeal. They are making a conscious decision to bring that appeal against their conviction. And in doing so, it is not difficult to see a rational reason why in those circumstances the existence of the risk of an RDCO should be seen as a matter which concentrates their minds as to the decision as to whether or not to appeal. Respondents to contempt applications don't have that choice. It's not their choice to bring the proceedings. They are the subject of proceedings brought against them. And indeed, they are subject to proceedings brought against them in circumstances where the opponent in those proceedings is not the Crown. It's not an opponent that's subject to usual prosecutorial duties. It's an opponent that is bringing or is entitled to bring those matters to serve their own interests. And it's an opponent who has the conduct of those proceedings and may well be very well resourced. So in contrast to an appellant against a criminal conviction, we have respondents who face potentially very well resourced opponents, proceedings that are not proceedings of their choice, in circumstances where they have little control over the conduct of the proceedings and the costs to which they may be exposed, and therefore have little control over the costs they may have to incur through the legal aid agency in responding to those proceedings. And yet at the end of those, they are exposed, we are told, to a general discretionary decision that they have to pay all of those costs, plainly less advantageous than that of appellants appealing their conviction, and yet policy would suggest if any side was going to be favoured by a distinction between those two, it would be the alleged contenders, not the appellants.
It's not a general rule they must pay all the costs, is it? The obligation on the court is to require them to pay what appears to be reasonable in the circumstances.
By reference, indeed, by reference to that. So there are certain capital limits. So, for example, equity in the principal property and matters of that kind. But then the court has a discretion. Let me just, sorry, my lord, let me just double check on that.
So just because I was talking about the RDCO obligation, that's by Regulation 5.
Lord, yes.
The determination is that the individuals are required to pay such proportion of the cost.
Lord, that is correct, yes. Your lordship, give me 1 moment. Sorry, my lord. Oh, that's on the wrong page, which isn't helping. Lord, yes, and your lordship has, and we went to them earlier, your lordship then has at Regulation 12 onwards the position in relation to the assessment of financial resources. And just for your lordship's benefit, paragraph, Regulation 15, which is page 383, that sets out the main issues that need to be taken into account when considering the decision that's going to be made by reference to the financial resources. Lord, will you just give me 1 moment? Sorry, Lord, I just wanted to double check that. Our understanding, but we'll be corrected if we're wrong by the Legal Aid Agency, is that the effect of 5.1a is that absent a decision under sub B by reference to financial resources, but the starting point is that the relevant court must make a determination that the represented individual is required to pay the cost. So the starting point is they will pay the cost of their representation, that is the full cost. And then the alternative is the court can order such proportion of that cost in effect as the court considers reasonable, having regard in particular to the financial resources. So the starting point is full cost, but there is discretion on the court's part to order otherwise.
It's like that it's A and B are simply described or simply put as alternatives, A or B.
What?
Without a predisposition to one or the other.
My lord, I can see that, but the point is that it is certainly open to the court to order the full cost, and if not the full cost, obviously then that is primarily because of the financial resources. And as we've seen at 2, the maximum amount, of course, is obviously the full cost.
Yes, we're told by Regulation 15 what the court must take into account by way of financial resources. Presumably the court has a broader discretion to take other things into account.
My lord, yes. So, and your lordship can see that there is provision for, under paragraph 16, 16.2, where the relevant court requires further information or documentary evidence in order to decide whether to make a determination or the terms of such determination. So it is not limited just to taking into account the matters under 1A to C.
No. Would you accept that what may be taken into account under 5B would include such costs as are recoverable by the defendant if they're acquitted from the claimant or the applicant.
Yes, you can remain. Lord, yes. Sorry, that was a long pause before a short answer. Lord, thank you. So, Lord, can I then just, I've dealt with the point about the lack of adverse cross protection. Can I just deal with a sort of Sally that's set up in relation to that? It has been identified as part of the general circumstances of these matters that a party who is in receipt of criminal legal aid does not have the adverse cost protection that a party who's in receipt of civil legal aid would. And of course, where that becomes particularly acute is where you're receiving criminal legal aid for civil proceedings, where you're exposed to orders for costs against you. That is a fact of life. It has been commented on by this court in the Kukurian case, and it has been made clear that that issue, if it is going to be resolved, is an issue for Parliament to resolve and not one that this court can intervene on. It is suggested by the legal aid agency through Mr. Cohen that that's the same position that we are in here, that there is an absence of something that we are saying should be introduced, and that if we want that introduced, then it's for Parliament to introduce it. To be clear, that is not our case. We are not dealing here with the fact that there's an express statutory provision which provides somebody with some protection which hasn't been applied to these proceedings, and we are saying should be in some way. We are dealing with the interpretation of these regulations and why we say, for all the reasons that we have given, when you look at them, they cannot properly and logically apply to these types of proceedings because of the consequences that would flow from that application. So we're not asking this court to give us the benefit of a statutory provision that doesn't apply. We are asking this court, in the interest of this case, but more generally, to interpret this regulation so everybody knows where they stand and everybody knows whether this regulation does apply, which the legal aid agency says it does, or does not apply to those who are subject of contempt proceedings. So, my lord, where we end up, what is, it might be said, what do we say is the correct interpretation of Regulation 2? Well, our interpretation of Regulation 2, and this is where we come back if necessary to the INCO and CADA point, our interpretation of Regulation 2 is, as we have said in the single ground of appeal, that whatever else Regulation 2 does, it does not include within its scope proceedings where legal aid has been granted under under Section 14H of LASPO. Now, it could be argued that one interpretation of this is simply to say, well, Regulation 2 only applies to criminal appeals. But I'll leave it for Mr. Cohen to develop any arguments as to whether Regulation 2 has got any scope for application beyond criminal appeals, beyond the Crown Court. But whether it does or it doesn't does not affect our position, which is why we phrased it as we have in the ground of appeal, that whatever else it might do, Regulation 2 and the RDCO regulations do not apply to proceedings where legal aid is provided under Section 14H.
So your reading of Regulation 2 would be something like criminal proceedings, open brackets, other than those under 14H of provisions.
And I appreciate that is essentially, or could be said to be writing words into the regulations, but for the reasons that we've indicated earlier, that is a course which is eminently open to this court.
Well, is it that right? Because that's 14.1H of LASPO, which is such other proceedings before any court, tribunal, or other person as may be prescribed. You say it excludes all of those.
My Lord, I do. As to the extent to which there are other proceedings which may fall within the scope of the recovery regulations, as I say, I'll leave it to Mr. Cohen to develop that if he thinks that there's a material ground for distinction. But in any event, our core position, Lord, as I say, ultimately it is what we say in the ground of appeal. So it does not include civil contempt proceedings. Whether that is equivalent to section 14.1H or whether it's narrower, as I say, my Lord, our position is that these proceedings are not within scope as civil contempt proceedings, and if that is equivalent to section 14H, my Lord, then that's what we say. But our position is civil contempt proceedings are not within scope.
So let me see if I got this right. Your primary position then is that this is a question of construction in your case. Regulation 2 would read criminal proceedings other than those relating to civil contempt. That's your primary position. If that's wrong, then it's criminal proceedings other than those under 14H of LASPO.
Lord, yes, thank you, my Lord. Yes, it is, our position is as in the ground of appeal, but we do say that there is no material distinction between that and a position whereby the scope of the regulations does not encompass legal aid cases where legal aid is provided under section 14.1H. As I say, if Mr. Cohen identifies a material distinction, then I'll respond to that, but we say that the position is essentially the same. Lord, unless there are any further matters, that
Yes,
is our position.
I've got one question, Mr. Molyneux. As you'll have noticed, a substantial part of your skeleton argument was historical context. You say that an RDCO could not have been made in these circumstances when the 2001 regulations were governing regulations, and if there was going to be this, you say, substantial change in 2013, it should have been clearly signalled, and it wasn't. Mr. Cohen, for his part, has a different substantial section in his skeleton argument about historical context. And if you look at paragraph 22 of his skeleton argument, he says, the appellant's submissions miss a central point in the evolution of RDCOs, which is that the availability of an RDCO has always been related to the question of whether the services in question are subject to being means tested, itself being a function of whether the legal aid was civil or criminal. This was made clear in the explanatory notes to the 1999 Act, from which he then quotes at some length. What do you say about that point?
Well, Lord, the starting point, and I think this is why, but I'll let him speak to this, why my learned friend has introduced the extract from Arledge and the case of Reed Jones. There is, in our submission, a lack of clarity as to what the pre-2013 position was, as to whether or not the financial eligibility criteria applied to recipients of legal aid for civil contempt. There is some indication in the cases, well, there's one case relied on, where the court concluded, or the court was informed that that was the case, and Sir James Mumby, who was the president of the family division at the time, made the observation that if that was really the case, then it was something that needed to have something done about it, and Mr. Cohen will take you to that. So that there is, the way I would put it is, it is unclear as to what the position was pre-2013, and of course it's Mr. Cohen who's seeking to make that out, and the best he's been able to do, as we understand it, is this reference to Ree Jones, which is rather unsatisfactory. So we don't say that clear distinction and that clear coherent policy that he seeks to identify to explain the change is made out. But in any event, what we come back to is the point that I don't rail against the idea that there may be a policy-based reason for concluding that contemners or alleged contemners should be subject to some form of contribution provision, or indeed that they should be subject to some sort of financial eligibility requirement if that was the choice, or indeed a marriage requirement were it to be introduced. I mean, others may disagree with that, but it's not necessary for me to wrestle with whether those would be good ideas or not for the purposes of this appeal. What we come back to is the point that if there are reasons to do that, then the legislation that does it needs to hold together when it does it and have a clear policy that we can see that leads to that conclusion that that is what it does. And whether or not Mr. Cohen can tease out an explanation saying, well, if there used to be financial eligibility requirements and if they've been removed, then it may make sense to change that to a capital contribution requirement at the conclusion. We say it doesn't get him anywhere if he doesn't engage with the question of what regulations have been made, how do those regulations work, and what can we take from those regulations as to what must have been the intention behind the regulations that were made. And so if Mr. Cohen is right at paragraph 22 onwards, it may well be that a coherent set of regulations could have been introduced to give effect to that policy. But that isn't what we have. That isn't what these regulations do. And when you look at these regulations, we say it is inescapable that there is an illogicality and indeed an inbuilt and manifest unfairness if they are intended and if they are said to apply to recipients of legal aid for civil contempt. And unless that can be adequately explained away, the obvious conclusion is that in fact that policy is not the policy behind these regulations. There is a different policy behind these regulations, and that different policy was, as the explanatory memorandum says, simply to deal with carrying forward the 2001 regulations in the context of the 2013 changes with no change to policy. And that context was taking out Crown Court from these regulations and leaving these regulations to deal with the remaining matters that it would have been dealing with before those changes. That is a coherent policy. That is explicable. It's not only a coherent policy, but it's one which explains how the regulations are drafted and how they work. The alternative is a set of regulations that don't make sense if they're intended to serve the policy that Mr. Cohen says that they are there to serve. And so that's why we say there is more than sufficient basis for this court to conclude that the policy that they were intending to achieve was a narrow one, that Regulation 2 has been drafted in a way that makes it appear broader than the regulations properly show was the intention, and that the court can interpret Regulation 2 more narrowly, and the consequence of that is then a perfectly sensible and workable set of regulations.
So the policy must have been that people against whom contempt proceedings are brought shall have legal aid as of right, irrespective of means, and there are no circumstances in which they will ever have to repay to the state the costs of those proceedings.
My lord, yes, that is the underlying policy that is here. It was open to the legislative to say otherwise, and I go back to the point that this is, as far as we can see, the effect. For example, if there are contempt proceedings brought in relation to matters other than in the face of the court, in the Crown Court, the Crown Court regulations dealing with contributions would not impose a contribution order in those circumstances. Now, it is easy to see a policy which would say there should be a contribution, but what we are looking at is what we can take of the policy from the regulations that have been enacted, and the alternatives open to the court are a policy whereby alleged contemners are not subject to a requirement to make a contribution, or a policy whereby without express provision, without consultation or anything of that kind, alleged contemners are required to make a contribution and are required to do so in circumstances where the test imposed on them is materially different to and potentially materially substantially more disadvantageous than the policy applied to anybody else who's subject to the regulations. Those are the competing policies that we can seek to identify from the regulations. And in my submission, the first is entirely logical. The second, there is no logical explanation for, because the second is not a policy saying contemners should be required to make a contribution. It's a policy saying alleged contemners should be required to make a contribution in terms which are materially more disadvantageous to them than anybody else.
But unlike anybody else, they can never be required to repay them.
My lord, that is the position. I accept that, yes. And as I say, it is whether the court thinks that is the policy it would desire. That is, we say, the effect of this. And I've made the point, and at the risk of repetition, if we are correct, there is a coherent position which would be referable back to that policy across these sorts of proceedings in every jurisdiction. So Crown Court, County Court, High Court, Court of Appeal, Supreme Court. The effect would be the same. You're accused of a contempt other than in the face of the court. There is nothing that requires you to make a contribution to the legal aid given for those proceedings. If we're wrong, then the position is that we have different provisions for different jurisdictions. So the Crown Court has its own set of contribution regulations which don't address the point and don't give a power to impose a contribution. The High Court, there would be that power, and Court of Appeal and Supreme Court, the higher courts. County Court, I'll leave it up to Mr. Cohen to explain what he says would be the position in the County Court in those circumstances. Although since County Court legal aid is 14H, presumably the position we would arrive at is that the County Court, that power would exist, but a different position in the Crown Court. Again, it's not for me to ask this court any questions, but I beg the rhetorical question: what's the policy that would lead to that conclusion? What's the identifiable and logical policy that would lead to that conclusion? And we say there isn't one. Again, it's not a question of requiring this court to set policy. Of course, if that was what I was asking it to do, it would tell me no, obviously. It's doing the best we can to identify what the policy must be by virtue of what the rule makers have given us to work with.
Yes.
So, my lords, unless I can assist further, those are our submissions, subject to any reply to my learned friend.
Thank you very much. Ms. Elders? Yes. Okay.
My lords, I have 4 core submissions that I will be making over the course of the next half hour and on the other side of the short adjournment. Before I enumerate them, I will just make, if I may, 4 short rebuttal points, while these are both fresh in my mind, and I'm sure in that of the court as well. The first is, so far as contempt in the Crown Court is concerned, not in the face of court, but for non-compliance with an order. My learned friend and I are obviously agreed that that is means tested, and that goes without saying, given the definition of Crown Court proceedings and the financial regulations, which I will furnish this court with over the short adjournment. There is obviously a difference between us as to whether, in addition to the means testing, there is the risk, so far as the contemptor is concerned, of a contribution order. And again, I'll do my homework over the short adjournment. My understanding has always been that so far as non-compliance with Crown Court orders are concerned, that they are simply wrapped up under the existing legal aid certificate that provided representation in the Crown Court proceedings, and for that reason are part of the contribution regulations, rather than having their own self-standing entitlement. If you're ordered to disclose documents and you don't, then that's part and parcel of the legal aid certificate that's granted to the defendant, and for that reason is addressed as part and parcel of the contribution regulations. But I will, if I may, do some more homework over the short adjournment, so I can address you that point with greater detail. The next is again, I think my learned friend and I agree that these suite of regulations are not, to use his words, happy. But with that, in my submission, comes an even greater danger if this court were to enter into the fray, so to speak, to interpolate words into Regulation 2. And there is a stark contrast between the facts, for example, in CADA, which at page 69 involved no less than 4 government consultations and an express direction to the civil procedure rules to draft rules in accordance with the outcome of those consultations. It's page 69 of your authorities bundle, that gave a constitution of this court confidence to rewrite the CPR. And what we have in these circumstances, we are, in my submission, likely as well. And an illustration of that is the way in which the appellant's case on the words to be interpolated in Regulation 2 has evolved. If one looks at the appellant's skeleton argument at paragraphs 11 and 40, the proposition is that the recovery regulations should not apply to non-means tested criminal appeals. Those are the 5 words which it is suggested should be interpolated into Regulation 2. And
Sorry, say that again.
Non-means tested criminal appeals. It's paragraph 11 on page 17 and paragraph 40 on page 24. That is the written case, certainly as I have understood it. First sentence of paragraph 11, the intention of the recovery regulations was to permit the making of orders for the recovery of cost representation in non-means tested criminal appeals. That's 11, and that is repeated at 40. As before, Man J, Mr. Turk's simple contention remains that the recovery regulations properly interpreted were intended to apply only to recover the costs of legal aid advanced to fund ordinary non-means tested criminal appeals. That's the written submission as I've understood it. The oral submission has evolved somewhat and includes interpolating the words other than those under section 14H and or except civil contempt proceedings. And I simply make the point that that fact alone militates against the interpolation of any words whatsoever, because one of the central criteria before this court can do so is that not only is it satisfied as to what the purpose of the statute was meant to be, but it also must be satisfied as to how that is to be translated to the statute itself. And here we have uncertainty as to purpose, which I'm going to go on to address as my first of my 4 core submissions. But the fact alone that purpose, as it's put by the appellant, gives rise to proliferation of different expressions, and they're not expressions that mean the same thing, they mean radically different things. Ordinary non-means tested criminal appeals is a far cry from accepting all of the different forms of criminal proceedings under section 14H, which is a catch-all, which then leads one to regulation 9 of the general regulations, which I think I'm right in saying has got in excess of 15 to 20 different types of individual proceedings. So if I might just take you to that to make that point good. If one accepts that it is the first of the two alternative constructions that my learned friend put in his oral submissions and then turn to page 350. 350 behind tab 18. Regulation 9 of the general regulations provides for what are criminal proceedings under section 14H. 14H saying such other proceedings as may be prescribed. And if one looks at regulation 9, one can see a multitude of different types of proceedings, and it's only at the top of page 353 that we see the expression that actually catches civil contempt. That's right at the top, that's 5 at the top of 353. So with respect to the first of the two alternatives that have been put in my learned friend's submissions, in my submission it can't plausibly be suggested that when enacting the 2013 regulations, the entirety of these specifically identified criminal proceedings should be extracted from the recovery regulations. The alternative submission made, which focuses on the expression except civil contempt proceedings, also in my submission is inconsistent with the appellant's core submission, which is that there should be no change in policy from the 2001 regulations to the 2013 regulations. A difficulty that the appellant's submission faces in trying to draw a tangent from 2001 to 2013 is the fact that had it been the case prior to 2013 that civil contempt for non-compliance of an order was criminal legal aid, then it would follow that an RDCO would have been made against the appellant in these proceedings. And that's because the 2001 regulations excludes only those who have been acquitted from the scope of its code. So if we, for a moment, were to work on the assumption that non-compliance with a civil order was criminal legal aid, then the appellant would be subject to an RDCO under the 2001 regulations. That's page 334 of the authorities bundle. Behind tab 17, regulation 4.
So regulation 4 of the
2001 regulations 334, and it's 42D. So if we were to work on the counterfactual, which was that civil contempt for non-compliance with an order had been criminal legal aid pre-2013, it wasn't, it was civil, but had it been criminal, then the appellant would have been subject to an RDCO order because the defendant was not acquitted before Mr. Justice Mann. It's also important to bear in mind that these 2001 regulations, irrespective of that counterfactual, bit nevertheless on contempt in the face of court in civil proceedings. So if there was contempt in the face of a civil court, the 2001 regulations would apply. And to make that point good, if one looks at regulation 3, the 2001 regulations are indelibly tied to funding as part of the Criminal Defence Service. The Criminal Defence Service prior to 2013 was the body that administered criminal legal aid. And contempt in the face of a civil court was criminal legal aid under the Access to Justice Act. We see that at page 318 of the bundle. So 318 section 12 to F is contempt in the face of court, which is to be funded by the Criminal Defence Service. That's page 318 at section 12 to F.
And that's any court, including a civil.
Any court, civil or otherwise. And if one now goes back to page 333, an RDCO could be made for contempt in the face of a civil court pre-2013. Now, if one takes the words that are to be interpolated in the written submissions, which is non-means tested criminal appeals, then if that's right, the 2013 changes will have removed a category of offences which would otherwise be subject to an RDCO, because non-means tested criminal appeals, if that is what the recovery regulations are restricted to, would not cover contempt in the face of a civil court. And it follows that even if the appellant is right that there was to be no change in policy, none of the alternative constructions that are put before this court achieves that end, because the policy in 2001, insofar as one can be divined from it, is that if you are acquitted, you should not have to pay. But of course, that doesn't avail the appellant, because the appellant was not acquitted. So what the appellant is forced to do is to distort the principles of the 2001 regulations, and then in putting forward alternative words to be interpolated on Regulation 2, the appellant, by a side wind, removes from the scope of the 2001 regulations categories of offences that would have been subject to an RDCO. So if one uses the words non-means tested criminal appeals as the gateway under the recovery regulations, then this court will have removed from the scope of offences liable to a recovery order things like, for example, contempt in the face of a civil court, because that is a non-means tested criminal appeal, and it doesn't fall within the Crown Court contribution regulations. So, my lords, taking that as being the case, the appeal as put is not consistent with the policy said to motivate the words this court is invited to interpolate in Regulation 2, because actually, because the appellant himself was convicted, the golden thread supposedly leading the 2001 regulations to the 2013 regulations is broken. They have to do more than simply say, if you're acquitted, you shouldn't pay, for the obvious reason that they were not acquitted, and therefore that doesn't avail the appellant on this appeal.
Just going back to the potential wording of except civil contempt proceedings, and you mentioned that's inconsistent. That would then be inconsistent with the pre-2013 position, taking the assumption that had that been criminal legal aid before, an RDCO would have been made unless acquitted. If it hadn't been criminal legal aid, then there would have been no legal aid available.
My lord, I'm treating contempt in the face of court separately.
You don't
Contempt the non-comporter. But contempt for a non-compliance with a civil court order was civil legal aid and was means tested.
So there wouldn't have been legal aid for anyone who has any assets over the relatively low threshold.
Indeed, my lord, and I'm going to come to a number of authorities that make good. In my first substantive submission, which is at its core, that contribution and means testing go hand in hand. So before 2013, there was means testing for civil legal aid in what was described as quasi-criminal proceedings, and I'm going to come to the funding code after the short adjournment. The funding code being the document that set out the parameters of civil legal aid, and the funding code has a dedicated section to what's described as quasi-criminal proceedings, which includes any proceedings which has the potential to impact an individual's Article 6 rights. And those were civil legal aid, and they were means tested. And the purpose of the 2001 regulations, as we'll, again, I'll come to when I make reference to the explanatory notes to the Administration of Justice Act, was to rid the Crown Court of the onerous obligation of effecting means testing at the start of proceedings, and in its place give rise to a power to order a contribution at the end of proceedings, as the explanatory notes will go on to explain. So
Was that the 2001 regs or the 1999 Act?
99 Act expressed the purpose. The 2001 regs were made under the 99 Act pursuant to section 17, which was that purpose. The governing statute, so far as the 2001 regulations is concerned, it is at page 322, and it's section 17 of the 1999 Act. And what I'm going to take the court to, probably after the short adjournment, because I'm conscious of time before I get into the meat of it, are the explanatory notes that set out the purpose of section 17 to the 99 Act, and the 2001 regulations are then pursuant to that purpose, having been made under section 17 of the 99 Act. So that's page 322.
And now you said when you got to your feet that you had a number of rebuttal points before going on to your 4 core submissions. Have you finished the rebuttal points? And this was going to be core submission number 1.
That is why I'm suggesting we might take the short adjournment now,
All right.
if I may, because my
Yes.
4 core will then follow after.
Shall we break off now to 5 to 2? 5 to 2.
All rise if any more.